So just a comment, this bill only applies to counties of less than 100,000. And there's no one on this committee that represents any of those counties.
And I will call Senator Scheible to the table. Welcome. I believe we'll be starting with SB354 first. So please begin when you're ready.
Perfect, thank you. And thank you so much for taking the time to hear both of these bills this afternoon. My name is Melanie Scheible. I'm the state senator for District 9, and today I have with me Elliot Mallon from Alpine Strategies to talk about SB354. SB354, as you can see, has really only one section to it, so I won't do a long walkthrough of the bill, but I will walk through kind of the history of the bill and what the bill is intended to do. Nevada is a unique state in that we have we do not have a unified court system. Our court system includes municipalities, it includes justice courts, and it includes district courts. The judges who preside over the justice courts are called justices of the peace, and they are judges of limited jurisdiction. That means that they can't hear felony trials, they can't hear cases that in civil matters that rise over $10,000 in value, and they can only hear cases within their physical jurisdiction. In Nevada, in 2015, we passed a law that no longer requires those individuals to be members of the State Bar Association. So you do not have to be an attorney to be a justice of the peace in the state of Nevada. The purpose of SB 354 is not to make any changes to that scheme. The purpose of SB 354 is to provide every person in Nevada who votes for a justice of the peace, who has interactions with a justice of the peace, who is part of a community where a justice of the peace serves, which is everybody in Nevada. If you don't know who your justice of the peace is, ask me afterwards and I'll help you figure it out. To ensure that there is some kind of frankly, a quality control mechanism to ensure that people who are sitting on the bench have a basic understanding of the legal requirements of their job and the matters that they'll be sitting over. And so this bill has gone through an evolution, as all good bills do, and I have worked closely with my colleague Elliot, with the judges of limited jurisdiction, with the Supreme Court, and with the administrative offices of the courts and the Judicial College to establish that this process, which we've kind of outlined in subsection 3 of section 1, that says that the Supreme Court and the Supreme Court will develop a test for all of these individuals to take within 18 months of being appointed or elected to office, and they have to pass that test in order to remain in their seat as a justice of the peace. The bill purposefully leaves the option open for that test to be administered by the Judicial College or as part of the Judicial College training, or to be a separate function. We've had really good conversations with both the Judicial College and the judges of this jurisdiction and the Supreme Court, all of whom are very willing and able to take on the task of creating the exam and administering the exam. So the idea is that if any one of you who is not an attorney and is still, entirely capable of sitting as a justice of the peace, wants to run to become a justice of the peace in a jurisdiction where you don't have to be an attorney, which, by the way, is only places with populations of counties with less than 100,000 people. So we're talking about rural jurisdictions. If you were to live in a rural jurisdiction and you wanted to run for justice of the peace and you got elected to be that justice of the peace, you would be required to go to Judicial College. And what SB 354 says is that at some point between the time that you get elected and the first 18 months of your service, in addition to going to Judicial College, you would have to pass a basic exam, proving that you understand the laws that you're going to be tasked with implementing or enforcing, that you understand the obligations both ethically and legally of an attorney, and that you understand the ethics of a judge and the legal process that you'll be overseeing. And so the purpose of SB 354 is to ensure as we move forward that we continue to provide equal justice to everybody in the state of Nevada, and to ensure that voters feel confident that when they are electing somebody to the role of a justice of the peace, if that person does not have a law degree to fall back on, we have some other mechanism of ensuring that we're choosing people who will be able to faithfully fulfill the duties of that office. And so I'll turn it over to Mr. Malin for some more commentary.
Thank you. Good afternoon, Chair and members of the committee. For the record, my name is Elliot Mallon. I'm grateful to be here alongside Senator Scheible, who graciously agreed to bring this bill forward. Also, I'd be remiss if I didn't thank the stakeholders, as Senator Scheible mentioned, were great partners in crafting the amendment that is now SB 354. It's important to note that Article 6, Section 8, Subsection 1 of the Nevada Constitution vests the power to set qualifications of justice of the peace in this body in the legislature. As Senator Scheible mentioned, in 2015, AB 66 revised the requirements for justice of the peace for townships and counties and population of 100,000 or less to obtain that position. Nevada's justice courts are courts of limited jurisdiction that hear criminal matters, which includes traffic violations, small claims, evictions, and civil matters up to about $10,000. The Justice Court also issues temporary and extended protective orders against domestic violence and or stalking and harassment. Nevada is one of 8 states that allows non-attorney justice of the peace to convict in certain criminal courts. This can raise some other right to fair trial concerns for certain Nevadans. Currently in Nevada, depending on the population of your township, your justice of the peace may not be an attorney. Their only formal statutory requirement is to hold a high school diploma. However, there are rules from the court that requires these justices of the peace to attend judicial college. Within these rules are currently nothing that require a justice of the peace to take and pass an exam showing that they retained a sufficient level of knowledge to adequately address issues before them. We seek just to set that standard with a minimalist approach. It must also be noted that this is not an attack on the justice of the peace in our rural communities. They provide a very important function. This is only saying that we should ensure that our citizens, our fellow Nevadans, are protected and given the opportunity to have a judiciary that works for them, that serves them. A judiciary that they can trust, knows the ethics and law required to make sound decisions on the bench. Today, 27 states permit non-attorneys to be justices of the peace, Nevada being one of them. Again, this bill does not seek to change that. What it intends to do is to establish a minimal level of comprehension of legal ethics and understanding of the laws that they will be seeing at the absolute bare minimum. Nevadans deserve to know that those that have the ability to make life-altering decisions for them understand these issues. While many have said that this bill does not go far enough, and trust me, a lot of my colleagues downstairs have said this, I believe this is a step in the right direction, and this is a minimalist approach to making sure that Nevadans are protected with a judiciary that works for them and making sure that we actually have judges in those jurisdictions as well. So let me reiterate to make this very abundantly clear. This is just making sure that our justices of the peace are able to not only understand the issues before them and spot these issues. It's meant to protect Nevadans, the attorneys, the clients, and everybody that will be appearing before them. By having non-attorney justices of the peace take and pass an exam administered by the courts, this will ensure that our justices of the peace have the competency necessary to serve on the bench. That exam will be prescribed by the Supreme Court and must be passed within 18 months after taking the official oath, and will be required to test without limitation on judicial decorum, the application of the revised Nevada Code of Judicial Conduct, criminal and civil actions, and proceedings over with which a court has the Justice Court has jurisdiction, and the financial administration of a court. We are just, again, trying to make sure that Nevadans have a judiciary that works for them and works for all Nevadans. So thank you, and I urge your support.
Thank you very much. Looks like we do have some questions, so I will start with Speaker Yeager.
Thank you, Madam Chair. Thank you for presenting the bill. I have a few questions. I think they're all pretty easy and straightforward, but I'll go ahead and ask them. How many times can someone take the test? Can they take it more than once in the 18 months, or is it a one-time only option?
Melanie Scheible, for the record, it is unlimited, and part of the reason that we discussed an 18-month window is that if someone doesn't pass it the first time and they need to review certain sections of the Judicial College syllabus and go back and retake it, I think that they should be able to do that. But at some point, if somebody can't pass a test about the legal cases they're going to be presiding over, I think it's fair that the citizens of that jurisdiction get another chance to select a justice of the peace.
Thank you. Follow-up, please. Next question is, do you envision, I know this is just for justices of the peace who are not licensed attorneys, but do you envision it would be the same test for everybody, or would the test be specific based on the jurisdiction that the person is serving in?
Melanie Scheible, for the record. I would imagine that it would be fairly standardized. I could foresee some sections being different for different justices of the peace, but generally their limited jurisdiction is set out by the Nevada revised statute. So I would think that we'd be able to, that the Supreme Court would be able to write one test that everybody would take.
And a couple more, if I could, Chair. Thank you. So, one concern I have is this. It would be a pretty, I don't know what the phrase is. I would feel bad for somebody who ran for election and won and then was like not able to pass the test, right? And they essentially, it sounds like they get booted off the bench 18 months in. I wondered if you'd thought about the option of letting someone take the test before they become a candidate for election, so they'd be able to like at least have that locked up before they got their name on the ballot, campaigned, spent a bunch of money, although I think these races generally are a little cheaper than in our urban areas. But just wondered if that was contemplated in here, or if not, if that's something you'd be willing to entertain.
Melanie Scheible, for the record, I would be happy to either in practice or through an amendment allow for someone to take the exam before they register, before they file to run for office. The reason that that the amendment includes the 18 months as opposed to having it be a requirement of running for office is that we learned that when we all filed to run, we went down to wherever we went. I went to the Clark County Commission, and I brought proof of my address and my identity, and the county elections officials weren't comfortable with making determinations much beyond residency requirements. And so we couldn't really come up with a good statutory way to empower county elections officials to determine whether or not people had passed the test and with a passing score, and how they were supposed to provide proof of that, when they were supposed to provide proof of that. We went through, should it be within 30 days of filing? Should it be within 30 days of winning? So that's how we ended up with the 18 months within 18 months of election. I think it would be up to the Supreme Court whether they would allow somebody who hadn't been elected to also take that exam. I'm fine with it, but obviously I don't speak for them.
Thank you. And then last one, if I could, Madam Chair. I don't know the answer to this. I'm not sure if you do, and if you don't, I'm sure there's someone in the room that does. But I was wondering right now, for justices of the peace who are not attorneys, are they required? They have to go to judicial college, I know that, but are they required to do continuing legal education classes every year? I'm getting some nods, in the affirmative behind you. So it sounds like they are. So that takes care of my question, which is going to be, how do you account for changes in the law? But if that's already a requirement, then I think that satisfies it. So I didn't really have a question there, or not one that requires a response. So thank you for the time, Madam Chair. Appreciate it.
You're very welcome. Next, we'll go to Assemblywoman Gonzalez.
Thank you so much, and thank you so much for the presentation. I was curious, so if the elected person cannot pass the test and they are elected, so then what happens? Do we have to do like a special election?
Melanie Scheible, for the record, that would be up to the individual jurisdiction. Even today, different jurisdictions have different ways of appointing temporary justices of the peace based on their internal mechanisms. And so it would be the same thing. That person would be considered unqualified for the office, and that jurisdiction would have to replace them through their normal process.
Thank you so much. So I guess I'm just struggling with the concept of those voters losing out on the people that they wanted to have elected, and us saying that they are unqualified. We don't take exams here, and I'm just trying to understand the issue. I'm not a judge. I'm not in this space. And so they don't pass the test, and then that jurisdiction would have the authority on if they want to appoint someone in the interim of that, and then would they have another election?
Melanie Scheible, for the record. So two things. First of all, I do want to point out, and your question touches on this, that at least speaking for myself, what I envision happening with this is not that you will have people who don't pass the test. I think that, I practice in front of justices of the peace who are not attorneys. They are fantastic judges. I would not want them to leave the bench, and they will be grandparented in, for the record. But the purpose is to make sure that anybody who is taking on this job doesn't just go through the judicial college, and have that one directional instruction, but that there is a test on the back end to ensure that they retained it. And so I think that it is part of improving the judicial education for them. And what I'm hoping will happen is that everybody will take this seriously. They will attend judicial college. they will attend every day of judicial college, they will pay attention at judicial college, and that way they'll be able to pass the test and retain those seats. I think that, in the unusual case that somebody is really unable to pass the test, I think the two things. First of all, the purpose of the test is to give the voters a better barometer of, who they're electing to become a justice of the peace. Personally, I would like to know that, because we don't get a lot of information, and you'll hear about that in the next bill that I'm going to present. We don't get a lot of information about our judicial candidates. And so it would give me peace of mind to know that after they were elected, they fulfilled this requirement. But the other thing that I will say is that we do lose justices of the peace as it is, and they have to be generally, in most places, they'll be appointed to fill the rest of the existing term, and then the seat will be up for a normal election in the normal election cycle. And so that happens to voters already who vote somebody into office who then, resigns, retires, passes away, whatever the case may be, and they get somebody who's appointed instead.
Elliot Mallon for the record, and it's really important to understand that right now these justices of the peace, their qualification for the judicial college, there's nothing that shows that they retained any information. It's just that they showed up. So we're sending them to judicial college. The counties are typically paying for that, and we don't know what they're learning necessarily. We know what the curriculum is. We just don't know if they've actually learned while there. We're trying to make sure that we understand that they are qualified. They understand what the job is, the qualifications are, and what they're going to be seeing. Thank you.
Thank you. Next, I have a question from Assemblyman DeLong.
Thank you, Chair. I think my questions have pretty much been addressed by the questions from the previous two members. But so just a comment, this bill only applies to counties of less than 100,000. And there's no one on this committee that represents any of those counties.
Melanie Scheible for the record. In fact, it only applies to people who are elected to the position of Justice of the Peace who do not hold a law degree. And many of our rural Justices of the Peace are, in fact, attorneys. It's just that, for whatever reason, in 2015, this legislature decided that it was fair to say that if you live in a county of over 100,000 people, your Justice of the Peace has to be an attorney. But if you live in a county of less than 100,000 people, the requirements are different.
Thank you. Next, we'll go to Assemblywoman Monroe Moreno.
Thank you, Madam Chair. With the Judicial College, is there testing procedures as they go through the college? Is there a test at the end of the... Okay, so would it be easier to put a test at the end to make sure that the attendees were retaining what they were taught and have the test there?
Melanie Scheible, that is the intent of the bill, is to allow for that test to be administered at the end of the Judicial College. And it is purposely written with just enough room so that whether it's literally the last day of Judicial College, or they want a week to study for it first, or the Supreme Court wants to be the one to administer the test, either way is fine. But the purpose is to have the test within 18 months of election, so they've already attended Judicial College, and the test mirrors the Judicial College syllabus.
Thank you. I didn't see that in the amended language, so thank you.
Melanie Scheible, it doesn't spell it out explicitly. It doesn't mention the Judicial College in the amendment language, so I don't know how anybody would know that without having this conversation that we're having right now.
Thank you. Next, we'll go to Assemblyman Hibbets.
Thank you, Chair, and thank you for the presentation. Forgive me if I missed this in the initial presentation. In the subsection 3, it says examination prescribed by the Nevada Supreme Court. Has anybody checked with the Supreme Court to make sure they're okay with this?
Melanie Scheible, I think it was their idea, but they are okay with this, and they will be here to testify in support or neutral.
Thank you very much.
Thank you. Next, we'll go to Vice Chair Miller.
Thank you, Chair. And I just wanted to follow up on my colleague's question. I guess what I believe a question may be, and what I'm looking for is, if we're talking about asserting a test for the completion of the Judicial College, why aren't we just requiring the test for the Judicial College and for everyone who completes that program, instead of singling out individuals and districts and stuff like that? And I think many of us may be a bit surprised that there isn't already some assessment at the end of that program. So could you speak to why don't we just simplify it and make it, and that would cover anyone that would be required to go?
You're right, these don't really. Yeah. Elliot Mallon for the record. Thank you for that question. The reason why we did it this way, and that we worked with the stakeholders from the Judicial College and the Supreme Court and the courts of limited jurisdiction, was it gives the court the platitude to work with all of them in the interim to make this exam. And the other part of that is we also don't want to handcuff the Judicial College into, as we talked about, within 18 months of being elected. If we were to do it, we could handcuff them, and I would be uncomfortable doing that as well.
Melanie Scheible, if I could just add one more thing. I'll also just speak frankly to the process that we went through to get to this bill, which is that as legislators, we do set the qualifications for justices of the peace. I have not been involved in a bill before that tasked the Judicial College with any kind of curriculum change or told I don't know what our legislative authority or duties are over the Judicial College. And so I think it would be probably a different road to the same ends. And I'm open to a discussion about whether it's the better route to the same ends. But since we came at this from the direction of, qualifications for election, that's how we ended up being on a separate track from the Judicial College itself. But you could probably go that other direction and get to the same place.
Thank you, Chair.
Thank you. Assemblywoman Newby, I know you had a question, then I think it was answered. Just want to make sure. Okay. Does anyone else have any questions? Okay, seeing none. Thank you very much. And I see someone approaching. Please press a button, sometimes 2 or 3 times, and then state and spell your name for the record. Thank you.
Good afternoon, Chair, members of the committee. My name is John McCormick, John, last name McCormick, McCormick, Assistant Court Administrator at the Supreme Court, and as the Senator indicated, the Supreme Court is willing to administer the testing provisions. And just by way of note, the Chief Justice has been having conversations with the Judicial College on some of this, but again, as the Senator indicated, we didn't want to get too prescriptive in the language.
Thank you very much. I'd like to come back to the table and say a few final words.
Just that I appreciate you hearing this bill and remain open to questions and conversations after the hearing.
Thank you very much. And with that, we will close a hearing on SB 354, and we will open the hearing on SB 418.